My name is Erich Niederlehner, and welcome to my video bankruptcy blog. Today we're going to talk about bank accounts when they're frozen. Bank accounts are normally frozen by a judgment creditor, meaning that a credit card company or a debt buying company has sued you, received a judgment against you, and then is trying to collect on that judgment through wage garnishment or property attachment. And one of the ways to do that is to freeze a bank account. And you don't necessarily know that the bank account's frozen. The creditor's attorney normally waits until your paycheck goes into that account, and then they have all that money and they freeze the account. This can cause major problems because, like I said, you don't know that the account's frozen. You're still writing checks. The checks start bouncing, and in today's banking world, a bounce check is $35 normally or more. The store or mortgage company or whoever you wrote the check to normally charges you a fee, so you can have a ton of fees racked up in a very short period of time when your bank account does become frozen. Now, the creditors do this because there's only a certain amount they can get from garnishing your wages. But if they garnish your bank account, they can get the full amount. So it's a good way for them to get a sizable chunk of change in most cases, or in some cases, to pay off the debt that's owed to them. However, there are some protections. If you receive Social Security, railroad benefits, veterans benefits, supplemental security income, otherwise known as SSI, Office of Personnel Management benefits. These are federally protected, and the bank, the rule recently changed about 6-8 months ago, the bank has to determine what the funds are in your account, and if there are any of those federal funds or federal payments, they have to set those aside and allow access to them. So take for instance, you have some cash in your account and you also receive Social Security, and you get, I don't know, $800 a month for Social Security. The freeze cannot go on that $800 that you received from Social Security, and the bank has to allow you to write checks or withdraw that $800. Now, when when an account becomes frozen, it's important that you contact anybody that you have direct deposits going into that account. If you're still working and you have direct deposits on your paycheck into your bank account, you need to contact your employer immediately and get those switched to a new bank account. Sometimes this can take time. Normally it's when you're dealing with federal Social Security, that sort of thing, that takes them a while to get things straightened out. Your employee normally is as simple as opening up another bank account, giving them the new account, and by the next payday they can have it go into your new account. But definitely talk to your HR and get that straightened out as soon as possible. Also, talk to an attorney. You may be able to assert an exemption and get those funds back. Bankruptcy may protect you. By filing bankruptcy, an automatic stay goes into effect as soon as the bankruptcy is filed with the court, and that prevents the creditors from garnishing wages, freezing bank accounts, doing anything to collect on the debt, and your funds become available as long as they're exempt and when you file the bankruptcy. Also, the general rule is that any funds paid to a creditor 90 days prior to the filing of an involuntary bankruptcy that are over $600 are recoverable. So, if a creditor sues you, gets a judgment, freezes your account, takes $2,000 out, and a week after that happens you file bankruptcy, the general rule is that you're going to be able to get that $2,000 back into your hands when you file bankruptcy. But it's important that you discuss the short-term, long-term effects of filing bankruptcy, whether bankruptcy is in your best interest, and never rely on information found on the internet or wherever and try to apply it to your situation, because there may be some other rules that may apply or your situation may be different. So I encourage you to talk to somebody that knows the bankruptcy laws, knows about frozen bank accounts, and see how your situation stacks up to the rules. You can call my office. As you can see on the sign beside me, the toll-free number is 877-607-2228. Our website is shouldifileforbankruptcy.com. I'm Erich Niederlehner, and I would be glad to sit down with you at one of our 5 locations or do a phone consultation with you regarding bankruptcy and just the collection laws on freezing bank accounts, garnishing wages, and those sorts of things. I will say that time is of the essence when your bank account gets frozen, and this does bring a lot of people into my office because they've got a bunch of missed payments and credit card companies calling them and suing them and stuff, and they just kind of stick their head in the sand and hope that it'll all go away, and then a wage garnishment or a bank account gets frozen and they suddenly move it up to the highest priority and come in and talk to me. So if you're experiencing financial problems, don't wait until wage garnishment or bank account's frozen. Come talk to an experienced bankruptcy attorney and find out what your options are. Sometimes bankruptcy is not the best option, but you don't know until you talk to somebody and find out the process and what would benefit you or not. Again, you can call us toll-free or go to our website, shouldifileforbankruptcy.com. We offer free consultations. We have fair, affordable, and reasonable attorney's fees, and we offer payment plans as well. So contact us and let us tell you a little more about the bankruptcy process. Thank you.